Would you phone the door so I don't do it? Don't worry.
Sorry, did I cover up that plug there? I think is there a plug in there actually? Oh no, not. There is. That's great. Reassuring, isn't it? You've got a separate battery. Oh, that's very wise.
You went to cool.
Court rise if able. This appeal is a matter of Allianz Insurance PLC and others, and London International Exhibition Centre PLC and others. Parthead.
Lords and lady, we were dealing some passages in the judgment which were based on the agreed facts. And if we can go to a core bundle, which is 902 of the judgment. In 291, the judge, you can obviously read these to yourself, but what the judge does is effectively deal with the effect of the creation of the NHS on the functions of the local area departments. And the judge said it reduced the role of the medical officer of health by shifting community medicine out of local authorities' remit and into the NHS. Local authorities retain the responsibility for broad-based public health measures relating to food hygiene, environmental health. And in 292, he refers to the Local Government Act and National Health Service Act, the abolition of the post of medical officer of health, the replacement of district community physicians and regional area medical officers. The effect of this was to replace medical officers previously employed by the local government for each county with medical officers based on new area health authorities within the NHS. Then, if we can go to 294, what the judge there deals with is effectively the role of Public Health England, and in 295, the chief medical officer and indeed the deputy and the CMO for the devolved authorities. And then in 296, he says the CMO is the country's most senior medical advisor, providing advice to the Secretary of State for Health when necessary the Prime Minister. The CMO is also head of the public health profession, represents it within government. The role has three overarching responsibilities: provide independent advice on public health issues, particularly during public health emergencies, to recommend policy changes to improve public health outcomes, act as an interface between the government, medical researchers and clinical professionals. The CMO plays a prominent role in supporting the government's response to public health emergencies. Alongside ministers, CMOs are responsible for keeping the public informed on health issues of high public concern, explaining the government response. CMO plays a leading role in advising the national response to public health emergencies. So obviously, if there's going to be a national public health emergency requiring a national response, he's going to play a leading role.
Anyway, we've read this passage.
What point do
you want to make about it?
The point I want to make about it is effectively, if you are dealing with national public emergencies, and if the government is taking a national or looking at a national response, the CMO is going to be involved in that, advising the Prime Minister and the Minister of Health. And we can also just very briefly go to supplementary bundle tab 36, 2, 3, 4 to 5. and this is effectively dealing with the reporting or the duty to report notifiable diseases, and that is, we can start at paragraph 49, the statutory duty, and paragraph 50, proper officers are required every week to inform the UK HSA, which was the Public Health England at the time, of anonymised details of each case of each disease of notified. This must take within 3 days of the case being notified, within 24 hours notification for urgent cases. So although there is an obligation for the registered medical practitioners to report every case of a notifiable disease to the proper officer of the local authority, effectively the proper officer of the local authority is effectively a staging post for the report to Public Health England, as it was at the time, or UK HSA.
Well, is the or disjunctive there? Does the registered medical practitioner fulfil their statutory duty if they don't notify the local authority but do notify the local, what was Public Health England, health protection team?
I would have thought in those circumstances they would comply with their duty, because the proper officer, I don't want to use a pejorative, I mean, he's almost like a post box to transfer the information from the doctor to Public Health England.
So you are saying there is an obligation to do both? Or
no,
one or other?
I thought you asked me what would be the position if the doctor short-circuited it and just reported to Public Health England.
Well, I'm not describing that as necessarily a short circuit. I'm asking you whether that is a short circuit.
No.
By reference to the language at paragraph 49.
Well, it says or the local authority, UK HSA health.
Exactly. That's a disjunctive. That's a disjunctive or.
Yes. Yes. And if I can just show you one example of Public Health England taking over the role of the old medical officer of health. If we look at supplemental bundle 36, page 223, we've got paragraph 9, which is going back to the old legislation. Under Section 3 of the Infectious Disease Notification Act, 1889, the medical officer of health of the district was made responsible for receiving reports of cases of infectious diseases in the district from householders and or medical practitioners. If one goes to the passage which we have just read, which is paragraphs 49 to 50, you see that effectively the duty now is to report to the proper officer or the local UK HSA health protection team, and then proper officers of paragraph 50 are required to inform UK HSA of the details of each case. So effectively, UK HSA either directly via the doctor or in a sense via the proper officer receive this information as to notifiable diseases, which in the past the local medical officer of health used to receive. So that's what I want to say at this point about the background. And you've already seen, and I will have to show you the terms of the cover again for another point, but you've already seen that. And if I can make my submissions now, continue my submission, the only office holders known as medical officers of health at the time when the policy was taken out were the chief medical officer, his deputies, and the medical officers of the devolved authority. And as we have just seen in the agreed facts and the judgment, they had extensive involvement in relation to serious health emergencies, which would clearly include serious epidemics and pandemics.
So when you say they were known as medical officers of health, what do you mean by that?
Well, that was their term. What the chief medical officer, the term, the role did not include strictly chief medical officer of health. I think I misspoke there. They were the chief medical officer and the medical officers of the devolved authority and the deputies. But the only term, the only role extant at the time of the policy were the chief medical officer and the medical officers of the devolved authority. And I think the insurers, in both cases, don't seek to say that the policyholder should have gone down to the basement of Middle Temple Library to research the meaning of medical officer of health. And therefore, the background, the Victorian background, they do not say what was knowledge which was reasonably available to the parties when they entered into the contract. So that's something you can put to one side. The question is, what would these words have mean to a reasonable policyholder reading the policy in the light of the knowledge reasonably available to that policyholder? So we then say that we, on our side, do not take an absolute position. We do not say that these words only refer to the chief medical officer or his deputies or the devolved authority equivalent. We say medical officer can clearly refer, most naturally can refer to the chief medical officer and his deputies when one is talking about national restrictions in response to very serious medical authority emergencies, but they can also refer to whoever is advising a local authority when there are much more local restrictions. And we say that since the background to the powers which authorities have in respect of infectious diseases are given both to the national government, but also in certain circumstances to local government. And since, as we will see, the term public authority is a neutral phrase, it can refer to whichever is the relevant public authority in respect of the relevant restrictions. When one sees medical officer of health for the public authority, you in a sense ask yourself, well, which is the relevant public authority? We say it can be local or it can be central. And then you ask yourself, were these restrictions imposed with the advice, with the approval of the relevant qualified person advising the relevant authority? That's what the clause really directs you. And as I've said, we say public authority can refer to either local or central government. In the context of the notification of contagious diseases, it clearly refers to central government, and you've probably seen at Core Bundle tab 42, page 874, the definition of notifiable disease, which is at page 842 of the Core Bundle, where the term public authority, not capitalised, clearly in that context, it's accepted refers to central government. I mean, we may just look at core bundle 40, tab 42, 842. It's the definition section, notifiable human disease, an illness sustained by any person caused by food or drink poisoning, any human infectious or contagious disease, an outbreak of which the competent public authority has stipulated shall be notified to them. And it's in these circumstances, competent public authority means central government. So I quite accept that there are no capital letters here. It doesn't say the public authority capitalised. It says the competent public authority. But it does show the term public authority in the context of notifiable diseases, referring to a central government. And we say that there is no warrant to cut down the term public authority to mean local authority. And that makes no sense in the light of the fact that national government has extensive powers in relation to notifiable disease.
Does public authority there only mean national authority?
Well,
Does a local authority have any power to require notification of an infectious or contagious disease? I thought that was a national function of delegated legislation by the Secretary of State.
Well, I suppose one might say that as we have just seen the legislation relating to notification, you can notify it to the proper officer, or you can notify it to UK HSE, or you could, but if you do notify it to the proper officer, he's got to pass it on within 3 days, or within.
No, I'm on a slightly different point.
You're on a different point.
The notifiable human disease is identifying what such a disease is by whether a competent public authority stipulates that it's notifiable. That's deciding what diseases are notifiable. And I may be wrong, but I'd understood that is a purely national function.
It's a purely national. That is a purely national task. Yes.
So in this clause, public authority doesn't mean local at all. It's
No,
limited. It's limited to national. Is that right?
That was my point, my lord. Yes. In this context, competent public authority means national, exactly, which is a point which is adverse to insurers who say that competent public authority cannot refer to national. We say that in this context, it refers to national. I don't say that in the cover where the public authority, I don't say that in a sense the use of public authority in the definition of notifiable disease means that the public authority can only mean the national government. What I do say is that because in this same policy, in respect of this same cover, public authority, not capitalised, refers only to the national government, is a strong factor against the insurer's argument that in the cover, the notifiable disease cover, the public authority can only mean local authority. That's the point I make. And
well, the phrase competent public authority at page 842 may not necessarily be limited only to national. for example, the regulations may change so that local authorities have some role, or it may be the case that a local authority issues a requirement which I suppose it wouldn't be competent then if it didn't have the power to do it. But the regulations may change, and the policy doesn't care.
That's true. I accept that. I accept that. I accept that. And then it's worth looking at if an inquisitive policyholder wanted to look up in the Oxford English Dictionary the definition of medical officer of health and indeed medical officer. And I don't know whether you have got these documents are online, but I think we
have got something
Good.
from the OED on our...
Right. So what we have is, first of all, a screenshot of what you find. It's the last page. What you find if you look up medical officer of health in the OED, and you find nothing there. And then what you then do, the previous page, is if you're very inquisitive, look up medical officer, and then you find a definition which is a doctor appointed by a company or a civilian or military authority to attend to matters relating to health. And then it says in brackets, in Great Britain, the public post of medical officer of health was abolished on the 1st of April 1974. So the inquisitive restaurant owner will think, well, it refers to a term which was abolished nearly 50 years ago, so it can't mean that. So it's really talking about a doctor appointed by, well, it's not going to be a company in this context, it's going to be appointed by a civilian authority to attend to matters relating to health. And again, a civilian authority is a neutral word, if I can put it that way. It's a bit like a public authority. And it can refer to a local authority. It can refer to central government. A civilian authority in this context means a governmental authority, whether local or central. So,
But I think your case is that it's not limited to doctors.
it's not limited to doctors. It's somebody who advises. I mean, it might be that person might have some kind of medical qualification, but I would be prepared to accept in a local government context it might be someone with a public health qualification. It's not necessary that they have to be called doctor this or doctor
Well,
that.
environmental health officers close down restaurants for all sorts of reasons.
They do. They do. So I don't need to be prescriptive at all. I'm quite open to that. It's the insurers who effectively are being dictatorial or trying to be prescriptive to say the clause can only mean what they say it means. I mean, it doesn't matter to me whether in the context of a local authority, because we're not dealing here with local authority restrictions, it can refer to someone who has some kind of qualification in public health, who advises the local authority. Because once you use a redundant term, a term that's really not been in use for 50 odd years, you have to make the best, you have to do the best to make sense of the clause in particular contexts. And that's the way we put our case. Now, if you are talking about central government, you are talking about the chief medical officer. If you're talking about the English government, the chief medical officer and his deputies, you're talking about the Welsh government, then it's obviously the Welsh chief medical officer, and so on and so forth. And we say, I think the insurers at one time say no reasonable person who wished specifically to describe the chief medical officer would use the phrase medical officer of health for the public authority. But the problem with that is this clause is not specifically or exclusively aimed at the chief medical officer. If you wanted to use a term which was appropriate for the relevant medical advisor for the relevant public authority, I'm not saying you would necessarily use medical officer of health because you're using a redundant term, but you would use something like the relevant medical officer for the public authority. And that's what this basically means. It's really a sort of omnibus term. And if I can just move on, we say that if I can come to the point of advice and approval, we say it doesn't require any knowledge of the particular circumstances of the premises. What is required is the restrictions have to be imposed with the advice or approval of the medical officer of health. Nothing is said in the clause about the requirement for particular knowledge of specific cases of disease at these premises. And of course, in the peculiar circumstances of 2020 and the pandemic, knowledge of the extensive scope of the pandemic and the numerous thousands, if not a million cases in the UK, led in our respectful submission to the imposition of these restrictions. And those restrictions, and I quite accept, it's for us to prove it, it's not accepted, but it's not a matter for this appeal. The national restrictions were imposed on the advice and with the approval of the chief medical officer. And that's all that needs to be done. He doesn't need to know that there were cases in the Kaizen restaurant or Umberto's restaurant. He just needs to know, and it's very similar to all the arguments we placed before, that there are hundreds of thousands, if not millions of cases in the UK which require action and effectively require businesses, all businesses, in certain categories, in this particular case, from our point of view, restaurants or sandwich bars, to be closed. And
what do you say is the purpose of the additional requirement of having medical officer participation? If it weren't there, you've got to show closure or restrictions as a result of the notifiable disease occurring at the premises by the authority. Why should it additionally have to carry with it the advice or approval of some medical officer? What's the commercial purpose for that?
the commercial purpose, I would suggest, is that the restrictions have to be imposed in an informed way. I suppose if you were looking at this from a purely, if you were dealing with a local case, I suppose the insurers would not want to provide coverage, although it would be harsh if this is right, where some local authority inspector who's unqualified and just says, right, I'm going to close you down. It wants to provide cover where there's a properly considered decision
But that requirement is not there for paragraph B of the clause, which is also talking about closure consequent on illness or injury, but not necessarily a notifiable disease. So obviously, the requirement in the first part must be intended to add something for some reason, if it's been thoughtfully.
I suppose the other way of putting it is that if you're dealing with notifiable diseases, you're dealing with something, I won't say rodents are not serious, but you're dealing with something on a much more serious level, and therefore, in those circumstances, the restrictions may well be more extensive, even if you're dealing with a local restriction, but certainly if you're dealing with a local restriction. Therefore, the closure may well be much more extensive. The losses thereby are likely to be much greater if the business is closed down for weeks on end rather than for a day or two. And therefore, the insurers want to make sure that if there's going to be a claim on the basis of a notifiable disease, it's a closure which has been ordered on the basis of proper consideration by the relevant authority, and for them to be properly advised by a properly qualified person with experience in these areas, rather than for it to be a sort of hair trigger panicky decision by an unqualified bureaucrat, if I can put it that way. I mean, that may be a reason. Now, I've already really made submissions about the meaning of public authority. We say public authority can mean both a central and a local government authority. The insurers are wrong to say it can only mean a local authority. And at one point they say the draftsman had a particular authority in mind. Well, if he or she did have a particular authority in mind, the authority was the draftsman was a pretty bad draftsman and didn't express that particular authority he had in mind clearly or with any kind of precision. It doesn't really matter what the draftsman had in mind, it's what the reasonable policyholder would think, and he would think that public authority is a term which can equally refer to local or central government, and it's a reference to whichever is the relevant public authority in the context of relevant restrictions arising from the notifiable disease. And the judge dealt with this, and I'm sure you've read the judgment, in Core Bundle 28, tab 28449, paragraph 318, where he says at the time the policy was placed, it was only the national government rather than local authorities which stipulated for notification of outbreaks of disease, calling the expression competent public authority in the definition section must include the national government. And then at 315, on the same page, he says this: I consider that applying the relevant principles of construction, summarising the FCA test case, any ordinary reader of policies issued to the Kaizen of Why Not Bar would understand that public authority have a broader meaning, which include national governments. And then he refers to Declaration 9, and in my respectful submission, on this point, the judge was entirely correct. If the insurers intended only to mean a local authority, they could easily said local authority. And if one goes to Core Bundle 42, page 869, which is the policy, one sees at 6F, one sees at 6F, all electric operated doors must be secured by either, and then there are various, and then it says any door or window officially designated fire accident by the fire authority excluded from these requirements. These are to be secured internally by panic bolts or fire extinguishers. Any additional devices are to be approved by the local fire prevention officer. So I don't want to place too much weight on this, but the draftsman was quite able to use the term local when he or she intended to mean local, as we can see. And then the judge, there was some discussion below about other references to public authority, and one sees what the judge said about that at Core Bundle 28, 449, at paragraph 317. The judge effectively said that Mr. Howie accepted it was elusive to search for a consistent meaning. I think he accepted that yesterday, and I'm not going to see, I'm quite happy to rest on what the judge said about that. I'm not going to take you to all that. So really my last point is to go to the reference or the reliance upon China Taiping. And it's necessary for us to look at that authority perhaps slightly more closely. And it's in the authorities bundle at tab 64. And
But the problem with China Taiping, I don't really want to cut across your submissions. The short point in relation to that is you've got a specific policy which specifically refers to a local authority. And the question was, do you squeeze into the meaning of local authority, national authority? So the starting point is completely different from this policy. And the issue is completely different from this policy. Now, speaking for myself, I don't see what China Taiping has got to do with anything.
yeah. Milady, you're not cutting across my submission, you're actually making my submission. And if one looks at China Taiping, they are the Lord Mance is dealing with a clause, and one can just see the clause at page 1531. And we may be looking at the clause makes the point, which one finds. It's at page 1531, paragraph 9, 1, denial of access. Assured section 2 is extended to include interruption, interference with the business in consequence of, and one is really, what one's really dealing with C, the actions or advice of the police or other competent local authority due to an emergency threatening life or property in the vicinity of the premises. Now, as my lady rightly said, the real argument there is whether competent local authority could or could not include central government. And after a long analysis, Lord Mance decided that it could not. When it said competent local authority, it meant local. En passant, the judge in this case said perhaps that might be due for some reconsideration, but that doesn't matter because we have different wording. We have the public authority, which doesn't refer to local. So I adopt what the lady says. Those are going to be my submissions once you see the form of the clause. So unless I can assist you further, those are my submissions in the Kaizen case.
Thank you very much, Mr. Gruder. Chapman is it next?
Thank you. If I may just move the furniture around first.
Yes.
My lady, my lords, I shall do my best not to repeat submissions that have already been made. and I intend briefly to add to those submissions or to relate them directly to the why not bar policy. And if I may first give you a roadmap through my submissions, I propose to deal first with the medical officer of health issue, divided into the appropriate starting point, the contractual context, and the statutory context. And I'll then deal with the knowledge issue, some preliminary points about the exercise to be undertaken, the construction of advice or approval, the construction of manifesting itself, and then what that means for knowledge as a matter of causation. Now, despite causation being the most important issue in this appeal as a whole, I don't propose to deal with it other than in respect of the knowledge issue. The 4 points made by my learned friend Mr. Christie KC are each dealt with elsewhere in my submissions within the medical officer of health issue or the knowledge issue, and the rest of causation is now well trodden ground that I don't intend to trample on further unless you wish me to do so. Yes? So the first of those issues is the medical officer of health issue and the appropriate starting point. And if I could please take you to extension 6A, which is core bundle, tab 46, page 951. That's closure or restrictions placed on the premises on the advice or approval of the medical officer of health public authority as a result of a notifiable human disease manifesting itself at the premises. So very close to Kaizen, few differences. And in my submission, the starting point is that public authority has a broad meaning, which on its ordinary meaning can obviously include a national government. I should say at this point that there's no magic in the use of the, because in my submission its only real significance is to highlight that it's talking about the public authority that actually imposed the restrictions or forced the closure. Now, although the words in a contract, of course, have to be construed in context, in my submission, it's really for the insurers to show why that ordinarily broad meaning needs to be restricted or cut down to local authority. And in fact, that's the starting point that the learned judge took at paragraphs 315 and 316 of the judgment. And in my submission was entirely correct to do so. That's at core bundle, tab 28, page 449. That's 315 and 316. Now, even if it's not expressly put this way by my learned friend Mr. Christie KC, the effect of the insurer's approach is to treat public authority as if it were ambiguous and without a meaning of its own. And in my submission, that gives too much weight to the various pointers that he relies upon in order to try to restrict that or cut that down. And in short, the insurer's approach sidesteps the fact that there's a clear meaning that the insurers need clear words to cut down. Now, the various attempts in my submission to cut down the breadth of public authority don't work because they distort the ordinary meaning of extension 6A rather than reflecting what the reasonable policyholder would understand those words to mean. So, in essence, the insurer's position over-engineers the wording of extension 6A beyond its ordinary meaning. Now, the first way, or certainly one of the ways in which the insurers seek to do that is by way of the contractual context. And there's particular emphasis upon extension 6C in that regard. And that, again, is at core 46, page 951. And 6C is dealing with drains or other sanitary arrangements. It's the closing of the whole or part of the premises by order of the public authority, the area in which the premises are situate, consequent upon defects in the drains and other sanitary arrangements at the premises. Crucially, in my submission, extension 6A and 6C are simply worded differently. 6A refers to the public authority without any qualification, and 6C has a qualification baked into it, which makes it area specific. And if for the purpose of this stage of the analysis, the additional words are taken to narrow public authority to local authority, then this actually reinforces the policyholder's case as to the proper construction of the words public authority. Because in 6A, there isn't any wording narrowing that down. Now, reading the additional words into 6A distorts 6A and doesn't acknowledge that 6C must be intended to be narrower. In short, 6C is qualified and 6A isn't. In fact, the additional words in 6C aren't inevitably as restrictive as the insurers suggest anyway. Public authority for the area in which the premises are situate doesn't have to mean local authority. It can mean local authority, clearly. It doesn't have to. It doesn't define it as local authority. Doesn't say anything about how small or how large the area needs to be. In fact, it says for the area, not in the area. And so that, in my submission, denotes responsibility and jurisdiction rather than just location. It may be location, but as I say, it could be wider.
So are you submitting there that it could mean England, for example?
Or in our case, Wales, absolutely. Yes, absolutely.
Yes.
So the precise meaning of 6C is academic anyway, because my submission it's not relevant to 6A. But even taken on its face, 6C isn't necessarily as restrictive as it's put forward to be. In my submission, the other clauses in extension 6 don't take the matter any further either. The insurers at paragraph 34 of their skeleton argument, which is at core bundle, tab 20, page 320, say that extension 6 provides cover for exclusively local matters and highly localised incidents and events which would be expected to and would in practice likely attract a specific response by a local authority. Well, in my submission, that creates an initial difficulty that it risks being construction by reference to paradigm examples. I won't go back to Corbyn and King for that, other than to mention Corbyn and King in that context. Now, looking at extension 6, in my submission, it's not the case that they occur exclusively locally anyway. So, sorry to push you around the bundle so frequently, but that's at core bundle, tab 46, page 951. 6A itself is a perfect example of not being exclusively local in my submission. And I should just, at this point, note the first of my friend Mr. Christie KC's points on causation at this stage, simply because it's a convenient point to note it, where he says that notifiable human disease isn't defined, which we agree with, and so it would still have a role to play if it was only localised cover. Well, I don't dispute the fact that it can have localised cover. In my submission, that's just saying that 6A can have a localised meaning. Crucially, it doesn't mean it can only have a localised meaning, which is where that submission needs to go for it to work for the insurers in my submission. Moving back to extension 6 as a whole, 6B, which relates to food and drink, could in principle be a widespread response to a widespread problem. The problem with food and drink could be, for instance, from a national supplier. So it needn't be restricted locally. 6C isn't...
Something like the horse meat scandal a few years ago.
Indeed, my lady. Absolutely. 6C isn't inevitably localised. There could be a similar problem in other properties, a design flaw with drains, a design flaw with sanitary equipment. It's clearly less likely, but it's not inevitable. 6D, well, murder or suicide at the premises, of course, would be likely to be specific to the premises. And 6E...
well, it might still have a national response. Might have the terrorist branch of Scotland Yard being involved.
Well, indeed. Yes, it could go wider. So even that would inevitably be exclusively. Absolutely. And 6E, in fact, has part of its terms that it's beyond the property at least because it's in the vicinity. And clearly this isn't the appeal to resolve the question of what vicinity means. But in fact, it's even further than that with 6E, because 6E actually refers back and reads back to covers to the property, in respect of property damage. And that property cover is at core bundle 46, 936. So this is obviously what's happening to the property that's in the vicinity that then causes the restriction. And various of these covers need not be exclusively local. For instance, there's earthquake at 2, riots at 3, storm or flood. Now, we do accept that it's more likely that all of these perils will be dealt with locally rather than nationally. But again, it's the same point. It's not inevitably the case that there will be. And so, in my submission, the insurers can't take the extra step that they need to take, which is saying that the effect of all of this is that it can only be local. There are specific examples as well where the government can act. Perhaps for your note, rather than going to it, at 6B there's reference to food safety. And the Food Safety Act 1990, section 6.3, which is in the authorities bundle at tab 53, page 1354, provides for the Secretary of State being able to discharge local functions. It's not a big point, but again, for the insurer's submission to work, in my submission, it would mean that the local authority should be the only authority that has the power to act in various of the 6A through to 6E extensions. Food and drink is a good example where that's actually not the case. I won't deal with China typing. My friend has already dealt with that, and I gratefully adopt the lady's comments in relation to that. The only point I would say is that, in a sense, China typing is the precise converse of this situation. So it's an attempt to expand what local authority means, rather than an attempt to restrict what public authority means. Even if the other extensions in extension 6 are to be treated as localised perils, in my submission, the argument really falls away long before we even get to this point. But even if those are to be treated as localised perils, that doesn't mean, in my submission, that extension 6A has to be treated the same way. So this is the Noscator point in Malone Friend skeleton argument. The common characteristic of extension 6A through to E, if there is one, is closure or restrictions on access. And there's nothing from the grouping of those together to go any further than that. And in fact, only 6A and 6C even make mention of public authority. As I've already dealt with, 6A and 6C have different meanings because of the extra elements. So 6A stands alone as referring to a public authority without qualification. And finally, on this particular point of contractual context, if I can just say there are examples in the policy of the draftsman referring to local authority when that's what's meant. The first of those is in the schedule to the policy. That's core bundle tab 47, page 1009. I'm afraid this is rather a poor copy. The meaning can just about be divined from it. The licensed premises condition, and there's reference there to necessary licenses with the local authority at G99.1, and then G99.5 makes reference to CCTV recordings. So this is in the schedule, of course not drafted at the same time as the policy that entered into.
So, I mean, the submission here is simply that there are other bits of the policy or the schedule which use the phrase local authority. It's absolutely, simply comes to that.
Absolutely, don't take it further than that. So that completes the contractual context. As regards the statutory context, I respectfully adopt the point raised by my Lord Justice Popplewell yesterday, that it doesn't matter what the actual legal position is as to whether all the medical officer of health's functions were transferred to the local authority, if the policyholder isn't taken to know the history that's needed in order to reach that conclusion. So that really is the primary point on statutory context. But to meet the points raised by my learned friend Mr. Christie KC and also my learned friend Mr. Howie head on this, I would like to expand briefly on what the common ground is on the point. I don't dispute what's been said about the common ground. The common ground actually goes even further as well. In essence, whilst there was a transfer of functions of the medical officer of health to local authorities in 1972, in 1984, the power to make regulations to prevent the spread of disease was given to the Secretary of State. And then in 2008, the further powers for public health response to the spread of infection were given to the Secretary of State. So, irrespective of whether or not all the medical officer of health's powers passed to the local authority in 1972, so even assuming that they all did, by 1984 and by 2008, at least the powers that have been specifically mentioned in the agreed facts, and I'll take you to those in a moment, at least those functions had already gone off to the Secretary of State. And therefore, crucially, by the time of the policy, the functions that had been with the medical officer of health had been dispersed, at least to the degree of dealing with disease and contamination, moving off, at least in one respect, to the Secretary of State. So regardless what the position was when the medical officer of health post was effectively abolished, and where the functions lay at that point, by the time you get to 1984, which of course is important because it's the very same statute that my learned friend Mr. Howie refers to for his section 74 point on the meaning of authorised officer. By that point, there is at least one element that is potentially within the purview of the Secretary of State. It's a small point, but effectively it's not possible to, by the time of 1984 and certainly by the time of the policy, to say, well, every function that the medical officer of health had prior to its abolition is now in the local authority. Even if it did, I would say that really doesn't take it any further because of the primary argument, but just in terms of being clear about what those facts are. Now,
the 1972 transfer, we looked at this, but I've forgotten, of functions, was to area health authorities, not local authorities in the sense we've often been using it, was it?
Well, that's right, absolutely. So,
Not what we're thinking of as local councils.
no, localised authorities, I should probably say, or local, I guess with a small L, yes. Some functions were. And I was going to say, unfortunately, maybe fortunately, there's no need to trail through or no ability to trail through the legislative process because those aren't in the bundle. And the reason they're not in the bundle is because they are within the agreed fact. And those are within the supplementary bundle for Why Not Bar, at least, at tab 37, page 244. In fact, taking perhaps a step back to page 242 to begin with, the agreed facts as to statutory context. So 17 is simply acceptance of Excel. Medical officers of health. My own friend has dealt with the first elements of those. It's worth pausing at paragraph 21 on page 243. So these are the duties and responsibilities of local officers of health. And those are very broad. Obviously at that point very localised, but very broad when it comes to removal or prevention of causes of disease. Then the next jumping off point, as it were, is at paragraph 28 on page 244. So creation of National Health Service. Schedule 14 of the Local Government Act, transferred to local authorities or their proper officers. So some probably were to local authority in the sense that we now think of as local authority. So I wouldn't say that the local authority with a capital A and capital A had no input at that point. I can't say that. So functions of the medical officer of health as part of the reorganisation make their way into the local authority. But the 1984 Act, Public Health Control of Disease Act 1984, then, regardless of whether it does anything else as well or whether there's any other movement out, as it were, from a localised context to a national context, if nothing else, section 13 of the Act, which is referred to at paragraph 31 of the agreed facts, deals with regulations for control of certain diseases, and that gave permission to the Secretary of State to make regulations preventing the spread of any epidemic, endemic or infectious disease. So if nothing else, by 1984, there is a power or function that was with the medical officer of health, regardless of what authority it went through to get there, is now, by 1984, actually with the Secretary of State. And of course, I say is with the Secretary of State at that point. The 1984 Act permits the Secretary of State to make regulation, rather than themselves making the regulation. So it's the power to make the regulation. Section 74 is then referred to at paragraph 34 at 246. And in my submission, the short point on section 74 is that the wording of section 74, and it is a definition clause, is of the authorised officer in relation to a local authority. It expressly says that within the wording. It's at Authorities Bundle, tab 51, page 1340. So, in fact, that's saying nothing more that when one is talking about a local authority, an authorised officer is somebody who has any functions that correspond to what the medical officer of health did. That's the key to it in my submission. It's when talking about local authorities. So it's no surprise that at that point it brings into that play. That's not saying that one can't talk about what a medical officer of health did in a national government context. Returning back to the agreed facts, to page 246, please. That's the core bundle. Sorry, the supplementary bundle. Tab 37, page 246. The Health and Social Care Act 2008 and amendments to the 1984 Act. So, again, their powers were conferred on the Secretary of State in relation to infection and contamination, including introducing 45B to 45F, 45B to 45R to the 84 Act. And those then, again, include preventing, protecting against, controlling or providing a public health response. So clearly this is all now far more sophisticated than what the medical officer of health was doing, but brought down to its basics. The Minister of Health for in its original form was dealing with matters relating to disease by 1984, then by 2008, and certainly by the time of the policy. An element of dealing with disease was being dealt with at a government level. And then finally, for really completeness on this point, at paragraph 56 of the agreed facts, which is page 251, my friend Mr. Bruder KC referred to Public Health England. And just for completeness, at page 56, it's the same point for Wales, Public Health Wales, page 251, as I say, of the supplementary bundle. So, in my submission, the statutory context doesn't provide for a restrictive reading of medical officer of health, which of course is what the insurers are trying to achieve, because it's a number of different hurdles for the insurer, because the insurer has to say, first of all, that public authority is defined by reference to medical officer of health, that medical officer of health is exclusively local, and that therefore means that the public authority referred to has to be exclusively local. But in my submission, each of those propositions simply don't work. My Lords, unless we have any further assistance on the medical officer of health issue, I turn then to the knowledge issue. And the first point within that is the exercise to be undertaken. And in my submission, the ground of appeal treats this as both a facet of causation and as a facet of construction.
I'm sorry, just before you move on, I was just going back to the Food Safety Act 1990, section 6.3, which you told us enabled national government to perform functions in relation to food safety, which were otherwise allocated to local authorities. I think that's what you've said.
Indeed.
And I've just turned it up, and it provides that the Secretary of State may direct that in relation to cases of a particular description or particular case, that any duty imposed on food authorities shall be discharged by the Secretary of State or the Food Standards Agency and not by those authorities.
Indeed.
Were such directions in fact given?
I'm not in a position to say one way or another, my Lord. The only significance of section 6.3 within my submission is that it points to the fact, and nothing more than that, that central government has a role to play. So it's not a situation in which, in regards to food safety, so 6B, I think it was, that it's only ever the local authority that would be involved.
That rather depends on whether they've ever made any regulations pursuant to the power. I quite understand the point that if they have, you can submit that some of the functions that were formerly exercised by medical health officers and would have been exercised before such regulations by local authorities have, by regulations made under this statute, become functions of the national government, which I thought was the point you were making, but at the moment it seems to me to depend on whether there had been any regulations made pursuant to 6.3.
I wouldn't want to say to you that they have been. I'm not in a position to point to any.
All right, thank you.
But whilst it would certainly be stronger if regulations had been made enacting that power and activating that power, the very fact of having that power to make the regulations, in my submission, brings the national government into the arena, if I can put it that way. Because the only relevance of this in the context of construction of 6A is to break down the insurer's submission that effectively, and my own friend doesn't put it this way, but in my submission this is the effect, that all the other extensions of clauses within extension 6 have nothing to do with national government. Now, it might be that my learned friend doesn't quite put it as far as that, but in my submission it needs to get as far as that in order for it to work. Because otherwise, all that is really being said is, well, you might expect 6B to E to be localised, but they don't have to be. So the very fact that there's the power to make the regulations brings central government into the arena. But I don't put the point any higher than that. I was going to say I'd be happy to research the point in the time available, but there isn't much more time available.
Well, it's not, I think, dealt with in the agreed facts, but you have referred to and relied upon it.
Well,
I just wanted to be clear what you were saying.
Absolutely. And in fact, that's the short point, because it's not in the agreed facts. I absolutely can't go any further than that. And I don't think go any higher than that.
Thank you.
As regards the knowledge issue, so the exercise being undertaken in my submission is that the ground of appeal treats it as a facet of causation and as a facet of construction. It's perhaps worth going to the grounds, because the point's most easily seen there. It's core bundle, tab 7, page 104. And paragraph 8 deals with what is said to be wrong with the learned judge's approach. So the finding that it was unnecessary to prove that the relevant manifestation of disease was reported to or otherwise known by a medical officer of health prior to their giving advice or approval for closure or restrictions being placed on the premises. And then, so what's said to be wrong is that finding. And then paragraph 9, effectively as to what should have been held on the insurer's case, is that in my submission, really there are 3 interlocking elements in paragraph 9 of the grounds for saying that reporting or knowledge is required. So the first is inherent in the extension's causation requirements. It's the second line of 9. Secondly is the construction of advice or approval. That's expressly rooted in construction exercise, construed as a reference to. And then the third point is the requirement for manifestation. So the first of those in my submission is front and centre a question of the knowledge point that arises in all of the cases and stands or falls with the answer to the causation grounds of appeal in the cases before you. But as regards the other 2 elements, in my submission what's really happening here is that advice or approval and manifesting itself are being construed by the insurers in a way that means that knowledge is required. And it's then that knowledge requirement which is fed into what's required as a matter of causation. And so when looked at that way, this is first and foremost a construction exercise, which then informs what's to happen for causation. That's not to say there isn't a separate argument about causation. There is, that's the one that's inherent. But for this element, it's construction.
We have the complicating factor that it appears to be accepted that reasonable belief rather than actual knowledge is allowed for causation, which is why I would personally welcome some help from you when I put this point to your opponent. He said, well, it's a self-standing point, and I'm struggling to understand how, if causation requires reasonable belief, you get actual knowledge coming in through construction.
Well, absolutely, my lady, because that highlights the disconnect, because it's looking at it the wrong way round.
Yes.
What's happening there is to say, well, there's a causation requirement of knowledge in to some degree, if I can put it neutrally, which then informs what the proper construction of advice or approval of, or manifesting itself is. But in my submission, that's the wrong way round. Yeah. It's about seeing what the proper construction is, seeing if there's a knowledge requirement that arises from that construction, which then has to be fed into causation. As I say, that's separate from the general causation point. But I don't wish to put my own friends' points from, but one can see how that can work if the knowledge requirement is properly a part of the construction exercise and then feeds in. But in my submission, that doesn't arise out of the construction point. And also linked in with that, again, to, if I may answer my lady's point at this stage on that it's difficult to see how, if there is a knowledge point out of the construction that is to be fed into causation, it's difficult to see how that can either be diluted in terms of its nature when it passes through to causation, or alternatively strengthened as it passes through to causation. If the construction is going to inform causation, then it has to be the same knowledge requirement. And in my submission, what that actually highlights is that on our case, even the construction that is being contended for by the insurers would still be fulfilled by a decision based upon known unknowns, where there is in fact a manifestation at the premises anyway. So even if this construction exercise works, in my submission it still can't be freestanding, because that construction is still satisfied by the known unknowns test, if that satisfies the general causation test as well. So that's a long way of me saying, in my submission, it just doesn't work for that reason. But to approach the construction point head on, in my submission, the immediate difficulty with the construction is simply that Extension 6A doesn't say informed advice. It doesn't say what the officer needs to consider. And of course, it's not just advice, it's approval. So, whilst when analysing what advice means, one can think it would be difficult to give advice without full understanding of analysis. The same might not necessarily be true of approval, because approval could be jurisdictional. It could be signing off with a responsibility. And in fact, comes into the point about the commercial purpose of even having this at all. Because in my submission, actually, this is the way in which the public authority is engaged within the hybrid. This element of the hybrid doesn't say a restriction by the public authority, which then has to be as a result of the advice or approval. It's closure or restriction on the advice of the medical officer of the public, medical officer of health of the public authority. And so in those circumstances, this is the, albeit convoluted, way of engaging the fact that this has to be a public authority restriction. Now, it might be that the reference to medical officer of health is giving it a very health-based or medical-based flavour, and that's the reason for doing that. It might just be, as the judge found in his judgment, that this is just rather odd drafting. Clearly, I can't take the commercial purpose any further than that. But it does fulfil a purpose, is really the key point. And the purpose that it fulfills is to engage the public authority element of the restriction. So, with that in mind, as a matter of construction, in my submission, the advice or approval is simply a requirement for the way in which the restriction or closure is imposed in order to engage the peril. So as a matter of engagement to the peril, it is narrower than just a public authority requirement. It's not just any restriction or closure that's required. It's a restriction or closure that is on the advice or with the approval of the medical officer of health of the public authority. It's not really doing any more than that as to analysing what the component parts of the advice or approval actually are. Linked in with that, and sorry, I haven't taken you to the extension again itself. It's core bundle tab 46, page 951.
I thought the point against you was, if not entirely, then at least in part, founded on the word manifesting.
Well, I think it's both. I certainly will deal with the manifesting. Within the skeleton argument, there was great emphasis on advice or approval. So I need to tackle that head on, as it were.
Well, I think it was put on the basis that the relevant officer cannot possibly give advice, close something down or give advice or approval without knowing what's going on. That's the point, isn't it, that's being made against you?
The advice or the approval is the hook, as it were.
It's got to be informed advice or approval.
Yes.
And then the manifested point is used to bolster that.
And to be fair to my learned friend, I think that I'm separating out the arguments, and it might well be that my learned friend is saying that actually you do have to read them all as the composite whole. But there's then a question of which end of the swimming pool one dives into. Yeah. That's the difficulty with that. So how this works on the analysis of the clause, in my submission, is that the advice or approval is in respect of the closure or the restriction, not in respect of the disease.
Yeah.
I can't ignore the disease, but then we're into the overall question of causation. And in my submission, that really cuts through the element of the submission for the insurers, that this has to be based upon the manifestation at the premises, because that would read this as being advice, or well, it wouldn't. The approval actually wouldn't work. It would be advice about this particular manifestation, but that's not where advice or approval sits. Where advice or approval sits here is in the context of the closure or restriction has to be imposed, reading into the wording by the public authority, that is a closure or restriction that has been advised or approved by the medical officer of health. So it's a peril point rather linking into manifestation.
So the medical officer of health has to have advised the closure or approved the closure or the restriction, irrespective of which limb of the public authority actually affects the closure or the restriction.
Yes, on the basis that there's
They
no.
can't just close it down. They've got to do it having got advice or approval for that action from the medical officer of health, whoever that may be.
Yes, it has to be a medical health closure.
Yes.
Really, is the shorthand.
Yeah.
So, as a matter of construction, at this point, rather than causation, there's simply no need to add in informed, and there's no need to add in based upon the manifestation.
I think Mr. Howie would put it on the basis that you couldn't possibly have such advice or approval, which is a prerequisite to the closure, without the relevant medical officer of health at least being aware that there is an outbreak of whatever it may be on the premises in question.
Which would then feed in the known unknown points.
Yes.
So I don't say that's not an argument. I simply say it just feeds back into the causation argument. So it means this isn't a freestanding point. And it doesn't mean that why not, it means that why not bar is in really no different position to any of the other policies.
Yeah.
Sorry, can I just see if I've understood that? Are you saying that the two requirements are, one, closure by the public authority as a result of notifiable human disease manifesting itself at the premises, and two, closure on the advice or the approval of the medical officer of health, but that does not mean, three, that the advice or approval of the medical officer of health has to be as a result of notifiable human disease manifesting itself at the premises. Is that the point you're making?
Well, it's as a matter of construction, the advice or approval, it doesn't have to be a known, if we can put it that way. The advice or approval is in relation to the restriction. So, how the manifestation element then kicks in is the causal linkage. So the advice or approval relates to the closure. It's how the closure comes about, effectively.
I mean, in practice, it may be closely connected, but I think you asked that you don't have to have a causal connection directly between the advice and the human disease manifesting itself.
At causation stage. Clearly. Sorry.
As a matter of the construction of the clause. I think I understand the answer.
Which then leads into the question of what manifesting itself and whether or not effectively so actually get a manifestation rather than being an occurrence. There isn't any such. There's nothing that's the effect that the officer needs to know about the specific manifestation. There's common ground as to the meaning of manifesting itself. So it's the display of symptoms or the manifesting of the disease to a diagnoser by a positive diagnosis. That's common ground, and that's the FCA test case.
Is that an exclusive? Is that intended to be an exclusive definition, or simply to illustrate that diagnosis is enough because manifestation isn't required to take place at the premises? It seems to me slightly odd that if manifestation doesn't have to be at the premises and therefore be to somebody else, manifestation is limited to manifestation to a doctor for diagnosis purposes, as opposed to the sort of symptoms that would do, if they were at the premises, exhibited to friends and family at home. But was the Supreme Court limiting it to those two categories?
On the face of it, they're working examples, in fact, because symptomatic, if the starting point is a display of symptoms in order to manifest itself, so the clearest example of that is going to be actual symptoms at the premises. That can only happen there and then in terms of the display. The FCA test case at divisional court level effectively added in as another example of that, or situation where manifesting itself can apply as being diagnosis, because the display of having COVID is to the diagnoser. Now, on the face of it, the diagnoser doesn't actually have to be at the premises whilst the diagnosis is happening, but it must be, in order for it to be manifesting itself, it must be a component part of the diagnosis that the person had it whilst actually at the premises.
I mean, your clause does require manifesting at the premises. So whatever manifesting means, it's got to happen at the premises, which of course was not consideration in the test case. Now, going to the doctor afterwards might enable the conclusion that at the premises you were manifesting, but that's what's got to be established, surely.
Well, and if it was just the doctor saying you have COVID at the time of that diagnosis, that wouldn't be enough. But if the doctor was saying you were at the premises 10 minutes ago, you have had COVID for the last 3 days. I mean, that
seems unreal to me. The doctor's going to diagnose whether you've got it. He's not going to ask, where have you been for the last 3 weeks? And did you have it when you were here? Did you have it when you were here? Did you have it when you were there? That's just not going to be an aspect of diagnosis, is it?
Unless it's a question of, for instance, perhaps with other examples where it was caught, for instance. But in a sense, sorry.
I mean, we need to look rather carefully at what the Supreme Court and the Divisional Court were saying, because I'd understood them to be saying diagnosis will do because you're manifesting it to the doctor when you're being diagnosed. And it is manifest to the doctor. And that is uncoupling the manifestation from something which takes place at the premises. Now, if that is the correct reading of it, then I understand your arguments. But if, on the other hand, as my Lord says, that isn't the correct reading, and this has to be an occurrence of a manifestation of something at the premises, then you are into the territory of it being something which is manifest, i.e. knowable and therefore known, at the time that it occurs, not a known unknown.
Well, it's a question of who it's known by.
Yes.
or brought to the attention
I
of.
think the language of the policy is different from the one that the Supreme Court was considering. And the point is that this one does link the manifesting with the premises. There's a manifestation at the premises, isn't it?
Well, it is, but it would be the same problem in a radius clause, because if it's manifesting itself within 25 miles,
Well, then it could manifest itself to a doctor if your local doctor happened to be there, but not if your doctor happened to live more than 25 miles away from the premises.
Unless the manifestation is really, which part of the manifestation is the operative part? If it's the actual diagnosis, in terms of the time of the diagnosis, then that would mean it has to be at the premises. Whereas if the actual process of manifestation comprises actually having the disease, albeit asymptomatic, at the premises, but then being told, perhaps, in fact, there weren't test kits at the time, but to use an example, going home, getting a test kit, you're only 5 minutes away, and it's a strong line on the test kit that effectively says you've already got COVID, then in those circumstances, it's at least arguable that the manifestation process is all the way from being at the premises. In fact, actually from when it's contracted all the way through to the diagnosis. But only if the diagnosis, if a component part of the diagnosis is that is that the patient had it whilst at the premises. It becomes
That would
quite
stop it being an
artificial.
occurrence clause.
Yeah.
Well, it becomes quite artificial in this construction context. And the reason in my submission why it doesn't affect the knowledge element here is because of the fact that simply being symptomatic is enough.
Yes.
And if there was a situation in which, in a clear case, so even aside from the construction aspect of what manifesting itself means as to when the diagnosis has to happen, it's still, a test kit is a self-test kit is a good example. So let's say actually at the premises someone had a self-test kit at that time, finds that they've got COVID at the premises, the temporal question then doesn't arise, but that still says nothing as to who has to know about that diagnosis because it's a self-diagnosis.
So you've got on the example you've just given us, Mr. Chapman, somebody has manifested the symptoms of the disease at the premises because they happen to have a PCR test or whatever there. And nobody can doubt that it's COVID on a particular day. The insurers seem to suggest that because Mr. Fred Smith has a PCR kit and has been diagnosed with COVID at the Why Not Bar on day X, it has to be shown that the medical officer of health, whoever that may be, knows about Mr. Fred Smith and his diagnosis and shuts the bar down because of it. That, I think, is the argument.
Indeed.
And it's a necessary concomitant of manifestation and advice and approval. You read the two together. In other words, you can't advise or approve the closure without knowing about Mr. Fred Smith having coughed and spluttered and done his PCR test.
So in my submission, where the limits of manifesting itself are in terms of the diagnosis aspect, in a sense, isn't where the argument, where the insurer's argument is, if I can put it that way. So as long as there is something that constitutes manifesting itself that the public authority won't know about because that's baked into what manifesting itself means, then in those circumstances, in my submission, that means the knowledge element doesn't run. So it's a subset of occurrence, it's narrower than occurrence, but there's still something that satisfies manifesting itself that doesn't require the knowledge of a doctor or public authority. Examples being within that limit, simply just showing symptoms or a self-diagnosis kit. I'm conscious that I haven't taken Your Lordship to the divisional court. For your note, it's at Authorities tab 1, page 48, paragraph 224.
The causation requirement in your case, in contrast with policyholders where there is simply a reference to occurrence, is that the causation has to be resulting from the manifestation as distinct from simply the fact that the disease is there. And the findings in the divisional court and Supreme Court case were by reference to the existence of all the cases in the country, not necessarily the manifestation.
Well, they did have some manifestation wordings there, didn't they?
Absolutely.
But they were manifestations within the radius.
Within the radius and not at the premises.
Rather than at the premises.
Yeah.
Which goes into whether that peril is then triggered. And with that in mind, really this is the third of my points about how knowledge fits into causation. The Supreme Court shows those different sort of structures, as it were, of the hybrid at paragraph 96. That's...
Sorry, you're just showing, so paragraph 7 doesn't require the diagnosis to be within the 25-mile radius.
It doesn't require it, no.
So manifestation wasn't regarded as a geographical question at all.
No, well, the manifestation means symptoms are apparent. Symptoms may be apparent at the premises or within the 25-mile radius, regardless of whether it's then subsequently diagnosed as being COVID by somebody who's outside the 25-mile radius. I read it.
Indeed. And page 48 of the authorities bundle it's the divisional court, but that was really common ground after divisional court. At paragraph 224, perhaps deals with Lord Justice Popplewell's point about whether it's an exhaustive definition. At 224, those really are illustrations of how manifestation can happen. It might be that those are the only ways in which it can happen. But there's an explanation there of two ways in which it does happen.
It might be said that, just coming back to what happens at the premises, simply displaying some symptoms, which happen to be symptoms of the disease, like coughing, isn't really what's meant by the clause, because what it's trying to identify is the manifestation of a notifiable disease, and therefore what needs to be made manifest, leave aside for the moment whether it's at the premises or somewhere else, but what needs to be made manifest is that it's the notifiable disease that is being suffered from. If you just have some generic symptoms, that isn't what this is about.
Well, because the symptoms have to be shown, yes, they would have to be symptoms that mark it as that disease.
So what would they be in COVID? It would mark it as being COVID as opposed to having man flu.
Well, certainly knowing what we know now, if someone was at the premises, we've got the owner there with his VAT return was yesterday's example, sneezing, coughing, bad throat, hot chest, says out loud, as it would have to be manifest, it's very strange, I can't smell anything or taste anything.
Yeah, but that's not a very helpful example, because you've tried to list a lot of symptoms that you could only have all of them if they were COVID. But is it sufficient on your case that they display all those but say nothing about losing a sense of taste or smell, in which case they would be entirely compatible with a mild case of a cold or flu?
Well, it would on the wording as or the analysis of manifestation in the Divisional Court and Supreme Court, because it's only saying the display of the symptoms of the disease. So it's not saying displaying symptoms that are then identified as the disease. It's really just saying symptomatic. So
what's the purpose of the requirement that it's got to be manifest, if all that has to be manifest is something that isn't going to tell you anything about whether it's a notifiable disease?
Well, it goes to the question of proof effectively, because, and this is why the difference between practice, the difference between occurrence and manifestation might well be very limited, because if someone's asymptomatic and then doesn't even have a diagnosis, beside the question of when the manifestation or where the manifestation limit is. But if someone is asymptomatic, doesn't have any diagnosis at all, it's difficult to see how they would even know they've had it for it to be an occurrence. So in practice, they may be very similar.
But if one symptom will do, seems to operate incredibly arbitrarily. The person with COVID who happens to cough while they're in the premises constitutes an insured peril, and the person who doesn't cough until he gets outside isn't. What's the sense of that as a construction of the insured peril?
It's effectively showing that someone had it whilst in the premises.
Well, it doesn't even show that they had it, if you're right, and all that's needed is a cough.
Well, if it later
Might
emerges,
just have had a tickle in their throat.
unless it later emerges that they had it.
But that's not on your case a requirement, is it?
Well, it stems from the nature.
Well, I'm sorry, it is. Yes, I see it is. Yes, it is.
And it's where the self-test kit example comes in, because that would then be a clear example. So the difficulty is that there can be so many hypotheses. I apologise if I'm being opaque with the construction of the limits of manifestation, because in my submission, really, this is about whether or not there is anything that satisfies manifestation that doesn't require knowledge. And in my submission, there are some very clear examples of that, and the very clearest is going to be a self-test kit taken at the premises, which one could well imagine.
You just got to stand back and apply a degree of common sense to all of this. It's highly unlikely that the medical officer is going to know that somebody coughed on the premises and was subsequently diagnosed with COVID. I mean, they will know that there are reports of various instances of COVID going around, which might ultimately prompt the closure.
Yes.
But it's back to the point that was being made about the circles and the spread and so forth.
Yes, absolutely.
Now, how are you doing on timing? Because we've got to take a break for the transcriber at some point, and I think you're on your final point, so presumably you've not got very long to go.
Well, I'm in fact there, because those points really
even better
deal with the causation. Really, the essence is that in my submission, all of that shows that this isn't a freestanding point at all. It turns on the causation arguments that you've already heard, and that I've promised not to go into, so I won't. Unless I'm with any further assistance, those are my submission.
Well, thank you very much. I'm glad I intervened. In that case, we'll take the break for the transcriber now, and we'll then have the replies from the insurers on this appeal.
All rise at table. Can I please remind the forum that the live stream is still running?
Okay then.
Well, I agree.
That's what that says.
That's the And I think you should know that. This probably comes from
No, that's fine. I didn't want to push them into giving us a limit to what manifestation constitutes. So you've already said it. And for our,
I think this point is
no, it's not. It's brilliant. Brilliant.
when it comes to causation,
Well, I don't
it's relevant for the company. I think that's what
I might. I'm going to cut it forward. I think everyone's going to stay on this road. Yeah. So we won't be so we might.
you're going to get Adam, you can.
Oh, that's a point. Sorry, I better wait.
Yeah.
Do I have to be there?
Okay.
I think the barracks.
I'll just start it back now.
Oh, sorry.
Neat for Oscar.
I'm going to put the lectern up now.
Go on, go on.
So of course, A is insurance.
I'm on it. You mentioned.
86 Supreme Court. Just in one conversation.
Oh, do you see whether we can get that back?
I wouldn't start trying now. I know.
No, actually, there's a very long flex,
I'd like
yeah.
to live
But it might strangle me in the way.
Yeah.
But it could, we could pass it back. Should we try? No? We can. Yeah, fine.
So we'll just pass it.
Give an extra 3 minutes.
Adam, do you want the?
Yeah, maybe. But let's get to that.
Do you want to? Yeah, if you move back now.
I can do without.
I want to refer. Maybe I'll refer to it.
We've got space.
No,
We'll do that.
Yeah.
The grandness, really.
Yeah,
We know that.
cool.
We
that's good anyway. No, because it was just the details.
Is that why everyone wants to do our mate?
yeah, I had to keep shifting around. Trying to see the bench.
Court rise if able. Court rise is April.
My Lords, my Lady, can I start with the point which was being considered just before the short adjournment in relation to extension 6 in our policy with the manifestation wording. And the key point here is that the causal sequence which is envisaged or stated rather in clause 6a is first that that the disease manifests itself at the premises, and that's a disease which is a notifiable disease, and that's different from the position in the divisional court where manifestation was discussed in the terms from the perspective of the diagnoser, as Lord Justice Popplewell pointed out. So the first part of the causal chain is disease manifesting itself at the premises. The second part of the causal chain is the advice or with the approval of the medical officer of health. And the third part of the causal chain is the closure or restrictions on the premises. And each of those parts of the causal sequence have to be satisfied in that particular sequence. So the starting point is you have to establish a manifestation at the premises. And that could be the displaying of symptoms of COVID-19 at the premises. Of course, we're looking at it through the lens of COVID-19. It could be measles or whatever. And that could be manifestation, could be a child with spots or whatever. But you have to establish the manifestation of the disease at the premises. And it's as a result of the manifestation of the disease at the premises that the advice or approval of the medical officer of health has to be given, resulting thereafter in the closures. Now, just unpacking those, what that causal chain indicates, we say, is a direct causal sequence between the manifestation, the advice or approval, and the action taken to close the premises. It's completely different from the manifestation within a radius clause, as the Supreme Court envisaged. There, they had to apply a different concurrent cause test in order to establish the causative effect of that manifestation. Here, we're in a completely different environment, and we are talking about manifestations at the premises and the consequence of those. And it's certainly accepted by Mr. Gruder, maybe not by Mr. Chapman, but certainly accepted by Mr. Gruder. I think it's page 16 of the transcript today, where he said that he was talking about the commercial purpose in response to a question from Lord Justice Popplewell. Mr. Gruder said that the restriction must be imposed in an informed way, and it must be a properly considered decision. And that is exactly our case in relation to the causal requirement in relation to this clause. You have to have a manifestation at the premises, not anywhere else. That must feed in to the medical officer of health, who makes an informed and considered decision in the light of the manifestation at the premises. resulting in the closure of those premises. And that is why, on the wording of our particular case, a direct causal requirement is compelled, we say. And the knowledge that is required is knowledge of the manifestation. Because that goes, as I said, if it's informed, it's an informed decision, an informed consideration. That must be with knowledge of the particular manifestation. So this particular clause requires the direct causal link.
So reasonable belief is not enough, you say, for causation?
Well, if there is somebody manifesting symptoms, take the case of measles, and I think actually, my lady, you put this point to me the other day, children manifesting symptoms of the disease at the premises, and that is, that information is communicated to the medical officer of health, who then gives advice to whoever takes the closure order or approves a closure order. That's the causal sequence.
Even though the manifestation could be satisfied without either the person believing it.
Well, if there's a display of symptoms which leads somebody always one symptom enough. One symptom could be enough.
Even though it wouldn't allow differential diagnosis.
Exactly. And the best case, the best case is the measles case. And so there's the manifestation of the notifiable disease, and that must be known to the MOH.
Even though it wouldn't be known either to the person involved, the patient, or to the shop owner, that the person had been suffering.
Had in fact been suffering. It may not be known to the patient.
And it may not be apparent to the
yes, possibly not, but it's not a requirement, it's just the manifestation at the premises. And then it must be known to the medical officer, who then gives his advice or approves the subsequent decision to close.
And you get that link, do you? Or the necessity for knowledge, which the sufferer doesn't necessarily have, from the words advice and approval.
Yes, my lady, yes.
That's the source of this inferential knowledge.
That is the source, we say, in the wording.
Yeah.
Yes. It's the combination of the manifestation and the advice oblique approval.
So would it be different if it just talked about a closure as a result of a notifiable human disease manifesting itself?
You would have a different causal sequence. Yes, it could be different. And in a sense, I don't need to answer that question because I haven't got that clause. But it would be a different causal sequence, yes. And what's critical with this clause is that three-part causal sequence. Can I move on to my next point? There was a short point which Mr. Gruder made, albeit in relation to Kaizen, but it's potentially relevant in relation to our case as well. I think he suggested that the under the notification regulations, the local authority is merely a post box. That is, I don't need to dwell on this point long because we're slightly short of time, but on our agreed facts, and I can give you the reference somewhere, it is clear that it's our agreed facts, SB tab 37, page 248, paragraphs 41 to 43. And it's clear there on those agreed facts. Perhaps we just actually look at them quickly. If tab 37 of SB 248, it's really paragraph 43, if we can look at that quickly. It says the (2010) regulations impose a statutory duty on registered medical practitioners to notify the proper officer of the relevant local authority where they have reasonable grounds for suspecting that a patient has a notifiable disease. The primary aim of notification by registered medical practitioners is to enable the proper officer of the local authority to investigate promptly and to take health protection measures to prevent the further spread or transmission of infection or contamination and to reduce the public health impact. So it's not just a post box. Third point, then, I've got 5 points and I'm on my third, is the medical officer of health point. The question here, it's not, what we're dealing with here, it's not an exercise in trying to work out in the abstract what title is given to the officers who advise central or local government on disease-related issues. The exercise is to work out the meaning given to the phrase medical officer of health in extension 6A. And that's not a question of adopting a restrictive or a broad meaning. It's just a question of finding the true meaning. So the question is, what would the reader understand by it? And it's not a question of how could the draftsman have done better, because the draftsman, in any case, can usually have done better. It's what the draftsman actually did. Now, Mr. Gruder's solution before the adjournment, he rejected all of Mr. Howey's options, and his approach was effectively simply to delete the words medical officer of health and replace it with any officer. And to use his exact words, this is day 3, page 151, lines 18 to 19. I think it was prompted by an intervention from my Lord Justice Males. Mr. Gruder, his exact words, where he said the words MOH identify who is the relevant officer who advises the relevant authority. So really, any officer, we say.
Well, not just any old officer, it's the officer with the responsibility for the notification to the authority of whatever the peril may be that leads to the closure.
Yes, it's the relevant officer who advises the relevant authority. Yeah. That's right, my lady. But what we've got to establish for the purposes of this clause is who that relevant officer is. And just puts it in construing it in a way which applies to any officer is to rewrite the clause in a way which we say it is not permissible. And the reasonable reader, and I'm going over ground here, but I'll do it very quickly. The reasonable reader, imbued with the statutory background that is relevant to the nature of notifiable diseases, would be able to give full meaning to the words medical officer of health of the public authority that reasonable reader would not need to delete or redraft it. The reasonable reader would identify the very statutes concerned with public health, control of disease, and notification of disease, which refer to former medical officers of health as authorised or proper officers of the local authority. And there's no reference in such legislation to medical officer of health having anything but a local role. Now, the medical office, the reader may not be able to identify whether or not every function that was previously performed by the MOH are now performed by local authorities, as opposed to central government. But that doesn't actually matter. That reader is concerned with what the phrase medical officer of health of the public authority means in the particular context of the extension which he or she has purchased. So the reader would look at the enabling legislation under which the notification regulations were made, that's to say the 1984 Act, and see that the Act expressly refers to the role of the former medical officer of health as a role now performed by proper or authorised officers of local authorities. And it's those same local officers, the proper officer, who receives notifiable disease notifications under the regulations. And that must be who the clause is talking about. And that's our position on the medical health. My Lord Justice Popplewell raised an issue with me yesterday about whether all the functions of the MOH had been transferred to the local authority. We've reviewed our agreed facts overnight, and there are no agreed or assumed facts in our case, my Lord, that support the proposition that any role previously performed by a former MOH are now performed by any central authority. So we're not saying necessarily that all of them were transferred, but for our purposes we say it doesn't matter, because here we're in the context of notification of a notifiable disease, where the proper officer of the local authority expressly has authority to receive that notification.
Even though that person would not be the person who was responsible for closing the premises down.
It may not be.
Well, won't be in reality with the notifiable disease.
Well,
I mean, one's got to look at the commercial purpose of this clause, and the commercial purpose of this clause is to give cover. And if it's construed in the manner that you suggest, then you notify it to somebody who isn't actually going to be the person upon whose advice or approval the premises are closed. Well,
it's paragraph 43 of our agreed facts, if that could be brought up. It's page SB 37248. 43. So it has to be notified to the, if we could go over the page on the screen, has to be notified to the proper officer to enable that proper officer to take any of those measures listed in paragraph 43. And that could include advice to close the premises or approval.
Advice to whom?
To the local authority to close the premises.
You don't have the power to establish.
The local authority will have power to close premises, yes.
For notifiable diseases?
Yes.
I thought that was the Secretary of State or the equivalent.
No, the local authority has powers under the Public Health Act to close premises. We can fish out the reference. It's section 42.
They can certainly close premises for other reasons.
45, sorry. It's one of the subsections of section 45. We're just fishing out the... Where are the pounds?
Right, well, it may be I've decided that something is a notifiable disease and closing premises as a result.
I think Mr. Hyde, he's a fount of all wisdom, and I'm sure he'll trace down the reference in a few minutes.
But we do, I think, have to proceed on the basis that the position is different in Wales from in England, on the basis of the different agreed facts.
Yes.
Right.
Yes.
Paragraph 43 says there is a duty to notify the proper officer of the relevant local authority.
Yes.
In Wales.
Yeah.
And the Kaizen agreed fact says that the duty is only to notify the proper officer or the local UK HSA health protection team. Maybe that is the basis on which we've got to proceed. The two cases are different. But,
well,
and
yes.
Maybe they are in fact different, but I would be slightly surprised if that was the case.
Yes. I doubt it. It may be that I think some of the information which is in the agreed facts, if you look at the footnotes, it's derived from government guidance. And I'm not. I'm just sort of speculating here. Some of it's related from government guidance, which is couched in broader terms and doesn't necessarily reflect the strict terms of the regulation. That's certainly anyway. Our position is it has to go through the proper officer.
Anyway, your agreed facts, footnote section 2 of the relevant regulations, and we've got those somewhere in the bundle.
Yeah.
I'm so sorry, my lord. Can I just clear that point up? Local authorities do have power to close premises, and that was accepted before the judge. We can find the reference if it's necessary. My lord, I'm sorry.
I was just
yes.
the agreed facts in the why not case.
Yes.
43 footnote 16. Do footnote section 2 as the source. And
yes.
I'm just asking for confirmation that when we go away, we'll find that section in the regulations in our authorities bundle.
It
is.
If
not, perhaps we could have.
I've taken you to that yes. to you actually. If you, I know you've looked at a huge amount of documentation. You can't have everything in your mind at once. Right. Yes, that is in the bundle. Yes. Sorry.
Well, perhaps that could be double checked, and if it isn't, we can be provided.
Yes. Yeah.
Thank you.
The definition of the public authority. Now, Mr. Chapman sought to distinguish 6A and 6C. I'm back to page 951, 6A, the extension itself. And he sought to distinguish 6C from 6A because of the words, the public authority, for the area in which the premises are situated. And he suggested, I think, that that area didn't necessarily need to be the area of Aberystwyth. I say Aberystwyth because that's where the claimant was, in fact, situated. And it could actually be Wales. In my submission, that's not a reasonable interpretation, or one that would be understood by any reasonable person, because what 6C is talking about is closing the whole of the part of the premises for the area in which the premises are situated, consequent upon defects in the drains or other sanitary arrangements at the premises. And again, that would be an intervention which would be carried out by the local authority as opposed to national government. One can't see national government being involved at that level of granularity. So in the context of this case, the area in which the premises are situated must mean the local authority. And if we, our point in, you've got our point in relation to 6A in any event, that the public authority if used separated only by 3 or 4 lines. Entirely accept it doesn't have those additional words in there. But the expression, the capital P public capital A authority, if used within 2 or 3 lines of each other, should be interpreted in the same way. And lastly, I think on China Taiping, there was an issue raised about the relevance of the China Taiping decision, and obviously that was a decision on competent local authority. We're not suggesting that you can lift that, the interpretation of competent local authority, and put it into slot it into our authority, to our case. The reason we rely upon Lord Mance's approach to the authority issue is because it was plainly correct. Because specifically, first, he correctly did not elide the matters in the parties' contemplation with what was ensured under the relevant clause. Secondly, he properly took into account the nature of the neighbouring perils as informing the type of authority contemplated by the clause. And thirdly, he rightly recognised the commercial sense in insurers wanting to confine cover to localised risks, attracting localised intervention. And so the fact that national and local authorities are empowered to intervene did not, in that case, mean that that was what was intended by the clause. And that's why China Taiping, and you've got the references, it's paragraphs 78 and 88, and also the discussion at 104 to 106. Yes, and this is my last point. The judge referred to this at paragraph 326 of the judgment, page 451 of tab 28. Yeah, and I touched on this yesterday when taking you through the judgment in the context of the overlap between powers given to local and national authorities. And at 326, the judge records my acknowledgement that those powers can be exercised by both local and national government. And he then set out, he referred to Lord Mance at 88, but what he didn't go on to say in the remainder of that paragraph, at paragraph 88 in Taiping, which is really crucial, is that it all depends upon the particular context.
Well, that's the point you made in your original submissions. I know that because I've written it down opposite that paragraph.
Thank you very much. Anything else? My lord, my lady, my lords, thank you.
Thank you very much. Mr. Howie?
My lord, my lady, I'm conscious of the time and the desirability of not outstaying my welcome. So with that in mind, I am not going to stoop to reply to the point about the electrically operated doors clause. I have 2 or 3 matters to address. The first 2 in answer to questions raised in argument by the court. The third just touching on the purpose of the medical officer element of the clause. The first point is that the question was asked to Ms. Gruder in argument as to who it is that stipulates diseases as being notified. This arose in the context of the Kaizen definition of notifiable human disease, which uses the phrase competent public authority. The short answer is that the position is as reflected in 318 of the judgment. At present, it is only national government that can stipulate diseases as being notifiable. That was not always the case. Section 16 of the 1984 Act, as originally enacted, allowed local authorities to stipulate diseases as being notifiable in their areas, and I don't actually have that section, but that is agreed in the Kaizen Brief Facts, page 225 and tab 36 of the supplementary bundle, but that is a provision that has since been repealed. So now it resides only at the national level. In the past it was both. Conceptually, of course, it can change again. And whatever one takes from that, The only point that matters, I submit, is that the meaning of a phrase like public authority or any variant of it has to be sensitive to the context in which it is used. And one cannot read across from the context of the notifiable human disease definition, which is dealing with competency to stipulate, and conclude that the public authority being referred to there is necessarily the same as the public authority being referred to elsewhere. It might or might not be, but whether or not it is depends on the clause you're actually construing, not on the clause that you're not. The second question that I need to pick up was about the point my Lord Justice Popplewell has raised about the Kaizen agreed facts dealing with the position in England and not Wales. The Kaizen agreed facts, it is true, do say that a report of notifiable disease can be made to a proper officer of a local authority or a UK HSA local team. I'm not sure how much thought was given to the disjunctive or and whether it was intended to have that much significance, but for what it is worth, the position as a matter of law in England is before you, because it is in the English regulations at tab 59 of the authorities report, which I just need to go to. Page 1435, Regulation 2, we've been to it already, and at 2.1, the duty of the doctor who finds that he's dealing with a patient who's got a notifiable disease is to notify the relevant local authority. The relevant local authority is defined in Reg 2.7. The local authority within whose area the registered medical practitioner attended the patient on the occasion of forming a suspicion of authority. So it may be that in practice notifications can also be given to local UK HSA teams. That point, by the way, in the Kaizen agreed facts derived not from the law but from a publication on a government website. It may be that the publication was using language slightly loosely, but the obligation is as I have outlined. Finally then, I want to touch on the purpose of the medical officer required. Mr. Christie was right to say, that Mr. Gruder's primary construction, at least, appeared to be that it is effectively any office of the authority. Yesterday, day 3, page 151, Mr. Gruder said it is the relevant officer who advises the relevant authority. This morning, he said the same thing in slightly different words, whoever is advising the local authority. So insofar as there is a seventh candidate, to go back to my taxonomy from the other day, it is just any officer. The problem with that, as Mr. Christie has identified, is that it doesn't give sufficient or indeed any weight to the words medical and health, still less to the overall composite phrase medical officer of health. Any officer is not what the clause says. One must take seriously in the constructional exercise the fact that the other words have been used. That is what drives, I surmise, the observation of Lord Justice Popplewell, that there may be some medical element to it, albeit perhaps in a looser sense. That is arising from the fact, two things in fact. First, it's arising from a correct understanding that the clause obviously requires the involvement not just of any officer, but of a particular officer who answers the description. And secondly, following that, one must then interrogate the presumed intentions of the parties in writing that into their clause. And I don't in fact disagree, nor I think it's Mr. Gruder, that the presumed intention in that regard is more or less as Lordship has suggested. The intention was to cover only the risk of closures dealt with through the proper and normal channels for the public health response to notifiable disease, wherein an appropriate officer with appropriate knowledge and qualifications will be involved. That's more or less the same as what Mr. Gruder accepted this morning when he said it has to be done in an informed way, or he agreed with my law's comment that it had to be done in an informed way on the basis of proper consideration by a properly qualified person with experience of these areas. I agree. What divides us, if it does, is how one gets there, because the route matters. The construction that seems to be in play against is that one gets there by a somewhat looser reading of the concepts of medical and health, so as to describe the officer or understand the officer as someone who might be acting by reference to some medical criteria. Mr. Chapman, in fact, this morning said it has to be a medical health closure, by way of short. That's really where the case has ended up. But that is not what the clause says. The words are not in my submission adjectival description of the officer's qualifications, nor of the criteria by reference to which the officer may act. They are expressly a description of the office, the post. And of course, that does import a certain understanding that the person will have appropriate qualifications and that they will be acting by reference to appropriate criteria, which may be medical criteria. And so it achieves the commercial purpose that we all agree the words must be intended to achieve, but it does it by reference to the post. And the post, for all of the reasons that have been explained and that I'm not going to repeat, is a proper officer who is the person who receives, in practice, as a matter of law, the report of notifiable disease. Unless I can assist further, those are my suggestions.
Thank you very much. Now, I think we've had all of the appeals completed, including replies. There is some provision in the timetable for what are called wrap-up points. I think, as I've understood it, the idea is that anybody in one of the appeals heard earlier in the week who feels that they've been affected by, or may be affected by, submissions made in later appeals should have an opportunity to deal with them. In the time available, I don't know how many people want to have a go, but I think the court feels that we've dealt with things pretty fully.
I would put my hand up, my lord, but I'll ask you the question. What I would propose to deal with, if you were assisted, was 10 minutes on Mr. Davey. Mr. Fawcett dealt quite briefly, perhaps necessarily, with the question of whether the Supreme Court in fact required only reported cases, and that was a large part of Mr. Davies' submissions. We have done a supplemental skeleton on that, so it's really a matter for whether your lordships would like to hear 10 more minutes on that, or whether they wouldn't.
Does anybody else feel they want to go? Mr. Keeley?
Yes, I want to address your lordships on one or two observations made by the court.
All right.
In the course of other people's submissions.
My lords, we got the supplemental skeleton that Mr. Kramer referred to the Monday before the hearing started. So I would like an opportunity to respond to the points raised. We certainly don't accept the points that are taken against us in that supplemental skeleton.
Right, well, you've got 5 minutes. Mr. Crane can then have 10 and Mr. Keeley can have 10. So you can go first, Mr. Davey.
The first point is that Mr. Kramer's supplemental skeleton is more notable for what it doesn't take issue with and what it does take issue with. We say it doesn't actually take issue with our supplemental skeleton in terms of contribution being the right causal analysis and contribution not being dealt with by the judge, and that causal contribution needs to be based on information that was taken into account. That's point number one. In parentheses arising out of the discussion the court had with Mr. Gruder, on whether medical officer for health is, what's the point of that, what's it doing? And it was indicated that the commercial purpose was to make sure that it was informed. The question for the courts we would submit is whether that medical officer for health policy is a different kettle of fish from ATP provisions that don't have it, or whether it's different fish within the same kettle. And by that I mean, is it doing something conceptually different, i.e. introducing something have to be informed, or is it actually just being more precise about the basis on which the action is taken? And we would suggest that it's just saying that the basis has to be specific in terms of the expertise of the officer. But there is always going to have to be a basis for a closure decision, otherwise it's arbitrary. So it would follow, therefore, that actually the concession about the purpose is of relevance to all of the ATP clauses and not confined to that. Responding to further points raised by Mr. Kramer, he takes the point that we gave up our case on known unknowns in our appeal skeleton. The reference is core bundle, tab 14, page 214, paragraph 53.4. We take issue with that. There was no concession. It was simply referring to the fact that if the Supreme Court was taking account of known unknowns, regardless of what it was taking account of, it wasn't taking account of visitors or employees, and the judge should have made that apparent in his judgment. So we take issue with it being a concession. He takes the point, he raises a number of points as to if we write about the factual basis of the Supreme Court being as we say, but it doesn't fit the overall picture. He talks about that there were no cases in the Scilly Isles, so how would that work? In fact, there were no cases in North Devon, but we accept that there was one place where there weren't cases. But that's de minimis, because if the court is taking a view of what the impact is in the entire country, if you look at that document, you say, that's what, it's in the country. So you make allowance for the fact that there's only one that's not there, so that's not a good point. Takes issue with the fact that there was no reference to 1 mile maps in the submissions by the FCA, rather than 25 mile maps. But that's not a good point either, because the position of the 1 mile is taken into account by what's happening in an LTA. An LTA is broader. There's going to be lots of 1 mile, notional 1 mile radial areas within that LTA. So again, that doesn't take him any further. He says that what we're contending for doesn't take account of Declaration 8, because Declaration 8 says you need to go out and prove the facts of whether there was cases in that actual premises. That's missing the point. Yes, you do need to do that, because the exercise that the Supreme Court was conducting was to say, well, have there been cases in these areas generally? So if you take the borough of Luton, which is 8 miles wide, all the government's saying is, was there one case there? Tick, yes there was. You fill it in the map. That's not telling you whether there's an actual case in the specific premises where the claimant is. So they then need to go and prove that. So that's not inconsistent either. There's a reference, and then the final point, because I don't want to take up more time. But even if we're wrong about all of that, and we, perhaps naively, we thought it was a helpful way to approach it in terms of analysing it. But suppose the court's against us on it and say that's not the factual basis, Davy's got it around his neck, he's got the wrong end of the stick. Our basic point about the approach to take to causation being informed by contribution is still there, because it's done on the basis of the interpretation of the policy and is justified by the wording of the policy and the fact that this is addressing risks that are different from radial cover. So it's still right. So you still have to judge whether there's anything in what we're saying about contribution based on information being taken into account. Those are my submissions.
Thank you very much. Mr. Greenberg.
My lords, my lady, I don't think Mr. Davies said anything I need to reply to on at the premises clauses. So I am confining myself to the point he makes that the Supreme Court deciding Ageas clauses was requiring reported cases only. And to do so, I will refer to our supplemental skeleton, which was filed on the day the court directed us to file supplemental skeletons, which is at CB Core Bundle tab 9A. And if the court goes to, well, firstly, if you see paragraphs 15, so we're on page, it's bundle page 156.7. Paragraphs 15 to 26 deal with this argument that the government was responding only to the 8,000 reported cases and that the other cases were just some sort of supportive backing, which is the new way that it's put, I think, that Mr. Davey referred to. We look at paragraph 19. So this is, you'll recall the point, it feels a bit silly to be excavating what things were said to the Supreme Court, but the point was, it was suggested again, as below, as rejected below, that Mr. Edelman, when relying on the maps, was therefore abandoning reliance on known unknown cases, and the Supreme Court therefore didn't rely on known unknown cases, and its whole point was that once you look at the map, you can see that there is a reported case everywhere within 25 miles. And the quotations here show you the references to there being more cases. This starts with the Sage Minutes, and then at 19.3, we have Mr. Edelman's submissions, mentions known unknown cases, and then 21 we actually cite AXA's, as I say, slightly new case where it acknowledges the importance of large numbers of unreported cases, but somehow excludes them from its causation test as having had causative impact. Clearly the Supreme Court said nothing like that. And then if we go down to paragraph 23, and then 24, you've seen the Supreme Court before, but 24 is some quotations that I won't take you through out loud to the submissions to the Supreme Court that were accepted. I also won't take you to the judgment below at 238, where the same thing is accepted, having looked at those same submissions. So that's about what submissions were made. That's all I'm going to say about that. On the question of the overall case and the points that Mr. Davey very briefly responded to just now, we go down to paragraph 26. So there's the models. Now, firstly, there's this odd quotation, because AXA itself seems to say that the government's referring to information about cases in general, whether known or unknown. We agree, that's the information. That is the information the government was reacting to. That's AXA's skeleton. Not below, here. The models themselves, I don't want to take you too deeply into that. You'll recall at judgments, I think we should probably turn that up, judgment 26 to 8, there were various facts that come from the agreed facts in large part about the models, and you'll remember my graph with colours on it.
Yes.
The graph had Cambridge, UCL and Imperial. Judgment 20, so this is, yeah, thank you. Screen caller. This goes on to then paragraph 28, which confirms that the government had various models and reports. These facts are not appealed against by Mr. Davey. He therefore has to accept them. And indeed, they were largely agreed anyway before.
Well, Malak, can I just clarify, we had our own agreed facts and we didn't introduce any of the model aspects?
I apologise. They're just not appealed against now. So Mr. Davey accepts them now.
No, our agreed facts are different from the agreed facts in Excel.
I'm saying only that part of the judgment's not appealed. There's
Right.
no challenge to the factual findings. That's all I'm saying. If we look at one more document on that, we go to Supplemental Bundle 34, page 155. We'll see the agreed and assumed facts on Mayfair. I think these are AXA's. And if we look at, so 67 to 8, if we just go, up to the page before, 67 talks about an Imperial College report, and underlying that is the Imperial College model, which was one of the lines on my graph. If we just go to the next page, we see Neil Ferguson was one of the authors. He was also on the SAGE committee. He's in the minutes listed. You then have at 70, the huge undercounting that's estimated there. They thought 2.7% of the country was covered. And footnote 35 confirms Mr. Ferguson was on there. And then paragraph 72, also it's agreed in that case that Cambridge were working with Public Health England to provide nowcasts. So I say that only because Mr. Davies sought to, I think, pour cold water on the idea that the government was looking at these models. They were, it's agreed that they were, and Mr. Ferguson was in the room on SAGE. And that's how we get to the 1 million figures. And although the SAGE minutes don't use the word million, it's clear they had this information, as the skeleton accepts. Very briefly then, just going back to our supplemental skeleton, you'll see the points made then at paragraph 25, which were some of those that Mr. Davey just skipped through. His case is that the reason there's no need to require reported cases in the declarations, etc., is because there was a reported case within 25 miles of everywhere, and therefore you can just make a declaration that the whole country has cover in that way. It's obviously not right for Silly Isles, as he accepts, because there was no one there and no one within 25 miles, just because of the amount of... No reported case. He said there were 5 cases. I didn't know that, but there were no reported cases. That's agreed. And then the second point is the more obvious one about the 1 mile clause. It's just a lot of the country did not have a case within 1 mile, a reported case within 1 mile. That's not disputed. The LTLA graphs, you'll remember the orange patches, were much larger than 1 mile. So it's just not possible to get from the one to the other. If that had been in the Supreme Court's mind, they would have had to say, we do have a lot more problem with the 1 mile because a lot of the country won't be able to claim, there won't be a reported case, and there's no equivalence, we can't reach any conclusion on that. But, of course, none of this is what was said. Paragraph 3 of our skeleton, we refer to that declaration that I think Mr. Fawcett did take you to. That shows how you can prove a case. And one of the ways of proving it is by statistical inference. This is a test case that was designed to guide everybody. The FCA then put up a calculator that helped people to prove, and these insurers have all been paying out on the basis of that declaration. But Mr. Davies saying, well, if anyone did come forward with statistical evidence and say, we infer there must have been a case here within 25 miles, Scilly Isles, or within 1 mile of here because we're in a city even though there's no reported case nearby because the hospital's far away, the insurer should say, well, that's no good, you have to have a reported case. That's never been said, there's been no case. And the declaration shows what the court anticipated. We put some of the declarations verbatim in paragraph 4. Those make no sense if you have to have a reported case, because the Supreme Court is just requiring the occurrence, as we know. And the final point is that I won't take you to. It's a thread that hasn't really been raised. It was this Professor Stapleton's interesting article, and we touch on that at 27 to 8 to 9. Mr. Davey hadn't relied on it. I wasn't going to mention it. It sounded like he maybe was when he talked about contribution.
Well, as you say, you've covered that in your skeleton.
Exactly.
We haven't heard much about it.
So that's all. That's all.
Right. Thank you very much, Mr. Kramer. Mr. Keeley.
My Lord, Lord, my lady, I know that my task in the next 10 minutes is to populate my 10 minutes with submissions that will have confirmed to you the views that you've already manifestly formed in my favour on quotation, which is why I only have 10 minutes. On day 2, Lord Justice Popplewell identified, and Mr. Kruger agreed, that it was the essence of policyholders' argument that notifiable disease is likely to involve an occurrence outside the area of the peril. Quotes, it doesn't matter whether it's a street, town, county or nation, unquote. The reference to disease, quote, posits a response which covers the area from which it has come, however small or large the area is. And that's something we take serious issue with. You've heard from Mr. Christie, but I'll repeat it, that none of the insureds in this case has been able to identify any previous outbreak of disease anywhere in the world that has led to a generalized closure or shutdown of all premises. That was a gauntlet thrown down at the trial, and it's a gauntlet which remains on the ground. You will probably know from your school days, and if not from your school days, from subsequently, that even the plague of Justinian in roughly 540 odd, which was the precursor to the demise of the Eastern Roman Empire, that was not accompanied by any generalized closure of premises at all. In fact, there has never been, according to the WHO, an unprecedented response such as we have had to COVID-19. The reason I mention this is because hindsight bias, is a well-known and established epidemiological and psychological phenomenon. Just because we know what's happened, you think that that is what people, before what happened, thought might happen, particularly insureds and insurers. Now, what history tells us, throughout all the diseases, whether they be cholera, plague, particularly plague, all that happened, it was very serious, but all that happened, there were cordons sanitaires around cities and islands. There were quarantine orders. In other words, if you had the symptoms of something, you were put in quarantine. There were lanzarotes established. In other words, plague hospitals called after Lazarus. There were leper colonies. There were vessel and other mandatory isolation orders. Those were all directed at people or places. Even SARS, 2003. It was hospitals or hospital wards, or in our case, it was border controls contract tracing in the East. In 1593, England suffered the last major plague of the 16th century. That bubonic plague had a far higher mortality rate than COVID did in England, and the Privy Council ordered only the closure of specific premises, most notoriously theatres. And that meant that Shakespeare's company, the King's Men, were forced to close down the Globe Theatre and couldn't perform. And if you remember, because you do, Romeo and Juliet, the reason why Juliet's letter never reached Romeo was because Friar John, who was carrying it, was suspected of having contracted the plague and therefore was detained in a house. In other words, he was subject to a premises-specific closure order. That is the historical background. And by the way, this goes all the way through to the 19th century. In the 19th century, physicians, scientists decided that quarantines were perhaps not the right way to go. Vaccinations were being thought about, etc. But this is the history. So it is wholly wrong to submit or to suggest that once the outbreak goes beyond a street, on our case, there is unlikely to be cover because the response will not be premises directed or specific. That is not right. That assumes that where an outbreak grows, the response is foreseen to be or expected to be an aggregate one without reference to any particular premises. Now, what history tells us is that that is the least likely, in fact, the virtually, if not totally unheard of, response. That's my first point. My second point, a point was made, and Lady Justice Andrews, day 3, page 16, mentioned that all types of venue of a particular type are in contemplation. Why it can't, she's struggling with the idea, why it can't be said that the specific places of that type are not also within contemplation? And your answer to that is because you've actually got to look at this particular address. But if that's not your case, I'd like to know what it is. I think that was addressed to Mr. Davey, my lady. When the government closed nightclubs, it was doing so explicitly on the basis that they were the types of places where people congregated in close and probably intimate proximity to
Like
each
the
other.
theatres in the plague.
Exactly. And were therefore potential hotbeds and potential breeding grounds of pestilential disease. In other words, they were where the disease is going to be multiplied. And if you could go to SB2, that's supplementary bundle 2.
They be multiplied, of course, Mr. Kingsley, unless there's reasonable belief that it's there in the first place.
That's where I disagree with you, my lady, because it is people going with COVID and then spreading it, which is why they closed those nightclubs. They didn't close those nightclubs in order for them to be cleaned because there had been COVID there. They closed nightclubs because they were the types of places to which people might go in the future and spread disease thereafter. And if one goes to SB2, divider 71, at page 89, at paragraph 92. And at the foot of the page, the Prime Minister says, this is the 20th of March, middle paragraph, we're going to defeat this disease with a huge national effort to slow the spread by reducing unnecessary social contact. Then you're required to, from Monday, stay at home for 7 days if you have the symptoms. That's rather like quarantine. Quarantine comes from quaranta because it was always thought that 40 days was a period when you would have a disease before it disappeared. But anyway, that's by the way. For 14 days, if anyone in your household has either of the symptoms, and then to avoid pubs, bars, clubs, and restaurants. And if you turn over the page, 2 pages to 841, at the top, we're collectively, third paragraph down, we're collectively telling cafes, pubs, bars, restaurants to close tonight as soon as they reasonably can, and not to open tomorrow. That's not because they already have the plague, as it were, but that's because they're the places where they might get the plague. And then we're also telling nightclubs, theatres, cinemas, gyms, and leisure centres to close on the same time scale. Now, these are places where people come together, and indeed the whole purpose of these businesses is to bring people together. But the sad thing is that today, for now, at least physically, we need to keep people apart. And then finally, 843. About 4 paragraphs down, it's vital to slow the spread of disease. And then about 4 paragraphs down, from this evening, I must give the British people a very simple instruction: you must stay at home. Because the critical thing we must do is to stop the disease spreading between households. Mr. Gruder attempted a similar point, day 2, page 104 to 105. He said the cases to which the government was reacting were in different types of premises. And I quote, those were where the cases hypothetically were. Then at page 115, he says, the government acted in the light of all those cases, whatever, I think he probably meant, wherever they were. The essential point being made is that all cases to which the government was reacting were in premises, whether they be houses, theatres, or wherever. But our case is very simple. The government would have acted in the same way, very same way, wherever the cases had happened, whatever the cases were. one might hypothesize that they might have been in this or other premises, but the government was not reacting in any meaningful sense by reference to where those cases were. It was reacting to cases everywhere in the only sense that it was responding to the general prevalence of disease. So I'll come to a close in a second. I think I've still got it closed. A second, rather. That is, by the way, everything I've just said, and everything I've just poured or sought to pour water over, cold water over, is the reason why you have a rageous clause. Now, everything I've said about disease spreading, about wide area reaction, that is, by contrast with an at the premises clause, what a rageous clause is dealing with. It might have been unprecedented, it might be historically regarded as almost impossible, but that is the, as people taught me with the words, the intrinsic character of a rageous clause. Hence, the rageous clause applies to the unprecedented circumstances, but an at the premises clause is a completely different animal. And lastly, in answer to my Lord Justice Mayles, who made a point on day 2, he said, if you have coverage for an unknown case of COVID, then you are unlikely to have a causal link which requires knowledge. Just one point. The key to that is that you're not asking yourself what causal link applies to an occurrence. You are, or should be asking yourself, what causal link applies to the peril. The occurrence is purely one component of the peril. You've heard from Mr. Howie in his clause what the peril is. In our clause, the peril is the closure of premises because of an occurrence at the premises, as understood from the 2019 perspective. The occurrence is part of that, but it is only part. And what the clause therefore conjures up is that the authorities have become aware, whether by statistical evidence or not, have become aware of what's happened at the premises and so have closed those premises down. So, those are essentially my submissions. My last point, or my last suggestion, is that you have to keep in mind that because the events of the pandemic were unprecedented, on either side's case, one must consider the application of the at the premises clause in relation to circumstances that nobody would ever have envisaged. That makes hard law. We're all just grappling with how the clause should be applied to extreme events, and one side or the other will regard the conclusion as harsh. Where one has a disease which is extraordinarily widespread, and so it elicits a response of extraordinary generality, it might be, and our suggestion is, that the insured is not on those extreme facts covered. But there is nothing odd or unfair in that, in the circumstances of my case. Those are my submissions.
Thank you very much, Mr. Keeley, and thank you very much to...
Well, I've just got one housekeeping matter. It's not a submission. The Supreme Court decision yesterday about Surrey Council, Lord Leggett does talk about causation in passing. He cites test case and he talks about but-for cause. I doubt anyone will want to make submissions. If it is anyone, it'll probably be the but-for cases, but I just wanted to mention it. Someone might want to write in or not.
Right,
but,
if anybody
it was
wants,
only yesterday.
If anybody wants to say anything about that, they must do so in writing within 7 days. Not encouraging it, but if there is anything which is relevant, then I suppose we ought to know about it. So thank you, Mr. Kramer, for mentioning that. We will reserve our judgments. They'll be drafted in the usual names have been given in. You'll be aware of the embargo, which the court takes seriously. We will hope and expect that in the light of whatever we decide, you will be able to agree between you the terms of an order. If you find you can't do that, then we will have short submissions in writing. As I said, we're very grateful to everybody, both those who have spoken and those who have not, and grateful too for the efficient way in which these submissions have been conducted, both in agreeing the timetable and in keeping to it. I hope that everybody feels that they have had a sufficient opportunity to set out what they want to say.